are awaiting a decision from federal appeals court judges about whether they will toss the election interference case against former President Donald Trump, who is arguing he had presidential immunity.
Former President Donald Trump is back in court today.
Donald Trump's immunity claim.
Trump was passing notes to his attorney.
Prosecutors called the Trump arguments frightening.
These cases can often get diluted in the busy news cycle, so I want to take time to examine this concept of presidential immunity and how it fits into this case. To do that, let's rewind the clock right now and bring you back to the 1970s. Volkswagen Beetles are driving around on the roads. Studio A here at WRAL is home to Mid-Atlantic Wrestling. And the Supreme Court was ready to make a ruling in a case that is ever so relevant today. July 24th, 1974. That was the day the Supreme Court made a decision that played a key role to President Richard Nixon's resignation. It essentially forced the release of the Watergate tapes, the smoking gun White House conversations.
I shall resign the presidency effective at noon tomorrow.
Paraphrasing the ruling, Nixon's status as president did not make him immune from being forced to release the tapes. The U.S. Constitution also does not give a free pass. Article 1, Section 3, Clause 7, which, in speaking about people who are impeached, says the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. Of all the places that do offer immunity, it's the place where Special Counsel Jack Smith works. The Justice Department. Back in the fall of 1973, just as the Watergate scandal was heating up, the Department of Justice's Office of Legal Counsel wrote a lengthy memo stating an indictment hanging over the president while he remains in office would damage the institution of the presidency virtually to the same extent as an actual conviction.
But if she did,
50 years after that Supreme Court decision, the U.S. District Court of Appeals for the D.C. Circuit will likely consider all of this as it weighs the election's interference case. To help us understand what Trump's lawyers are arguing and how Special Counsel Jack Smith is responding, I spoke with UNC professor Michael Gart, who is one of 4 constitutional scholars called on by the House Judiciary Committee during then-President Trump's impeachment hearings. There has been writing to some degree by the Supreme Court, by the Constitution, and the Justice Department about the idea of presidential immunity. What would you say is the most clear writing that could guide this panel of judges in the appeals court as they work through this case?
I think the clearest thing is that everything we know about the Constitution directly undercuts Trump's lawyers' arguments. So it's undercut by the text of the Constitution. It's undercut by a U.S. Supreme Court decision. It's undercut by historical practices. And it's undercut by the basic principle in American law that no one is above the law.
One of the Court of Appeals judges brought up this hypothetical during the most recent hearing on this case, saying that could a president order SEAL Team 6 to assassinate a political rival and not be prosecuted? Trump's attorney, John Sauer, says he would first need to be impeached first. What do you make of that?
It's a crazy argument. It's wrong. And I think the judges were rightfully quite skeptical of it. But it makes no sense at all. Trump's lawyers arguing that unless a president has been impeached, convicted, and removed for certain criminal misconduct, the president may never be held criminally responsible for that particular criminal misconduct. It's absurd. And one reason why it's absurd is because criminal proceedings are not the same as impeachment proceedings. There's language in the Constitution, as you pointed out, that suggests that legal or criminal proceedings are one thing, but impeachment is another. Or to reverse that, if somebody's been impeached, convicted, and removed, they may still be liable at law for whatever they did. The order or sequence of proceedings doesn't really matter.
My conversation with Michael Gart continues online on WRAL.com. I ask him, why haven't the Court of Appeals judges made a decision on this case yet? For his answers, search this story on our homepage or find it on the WRAL News app.